My name is Ben Morris, and I am the program administrator of the Admiralty Law Committee. And at this time, it's my pleasure to introduce Michael C. Black. Mr. Black has over 29 years of experience in maritime and transportation law and is board certified by the Florida Bar in Admiralty and Maritime Law. He graduated from Vanderbilt University in 1990 and received his law degree from the University of Miami in 1995. Mr. Black is a member of the Florida Bar, the Dade County Bar Association, the Maritime Law Association, the Southeastern Admiralty Law Institute, and other Admiralty and Maritime law organizations. He served as the vice president of the Propeller Club of the United States, Port of Miami, and has been a speaker at numerous conferences, as well as authoring several articles regarding cargo claims. He currently owns his own law practice, Michael C. Black, PA, in Miami, Florida. Welcome, Mr. Black, and take it from here.
Well, good afternoon, everybody. Thank you for being here today. I get the pleasure of kicking off the afternoon session here, talking about the scintillating subject of cargo. I was thinking about this earlier today. The couple of things that I love about cargo is, number one, the damages aspect are pretty straightforward. Liquidated damages, cargo is worth what it is, although there are some limitations that potentially affect it. But more importantly, it is not an emotional area of the law. Like you were hearing from Curtis and others this morning, Tom, about the torts, sexual assaults. I have yet to be involved in a cargo case where there was a deposition when any witness started to cry. That's nice when you don't have to worry about the emotional side of the case. And I'm sure all of you that handle personal injury cases know that can be a difficult thing, both from the defense side and the plaintiff side to deal with. Cargo is pretty straightforward. It's economic losses. Just a little bit of background from me. I started in 1995. I was hired to work with, a lot of you know, Bill Cassidy. Bill was a 100% cargo lawyer at the time that I joined him. He did very little other types of law, so I cut my teeth in the first few years of practice with him, only doing cargo. So it was a very exciting time. Pre 9/11, there was a lot of theft cases, a lot of port issues, damage to containers, but theft was a much more common event to cargo back then. Since 9/11, the ports have gotten a lot more secure, so we don't see as much of the cargo theft cases like we used to see. But the cargo cases are still out there, and I will start the slideshow. So, what law applies? The United States Carriage of Goods by Sea Act applies to all cargo shipments that originate from a foreign port and go to a U.S. port, or vice versa, a U.S. port to a foreign port. It applies on its own tackle to tackle. That means that basically when the ship's crane or the shoreside crane takes the container, puts it on the ship, COGSA applies on its own from that point forward until the container is or cargo is discharged from the ship at destination. It was originally codified as 46 U.S. Code Appendix 1300 et sec, but interestingly now, over the years, it's become an uncodified statute in a note that follows 46 U.S. Code 30701, which is part of the Harder Act. So it's interesting, over the years, COGSA sort of has become a little bit put into the corner, so to speak, from the perspective of the statutes, but it's still fully enforced, and it applies to all ocean shipments of cargo to or from the U.S. port. Unlike this morning's presentations that involve mostly torts, the cargo claims are basically contractual in nature. And the key document that originates any cargo claim is called a bill of lading, also commonly referred to as a BL. I have on the screen here a sample of the ocean bill of lading. And what you'll see is a lot of boxes that typically get filled out by a carrier or an agent for the shipper, or sometimes the shipper themselves. And it'll identify the shipper, usually in the top left-hand corner, the consignee right below that, a notified party, which means a agent for the consignee, usually a customs broker, or a freight forwarder, something like that, that will get notified when the cargo is delivered at destination. On the top right-hand side, you'll see a booking number, export references, the forwarding agent if there's a freight forwarder involved, and then domestic routing, export instructions, and some other identifying numbers. In the middle, as you go down a little bit, you see, and I can use my cursor, pre-carriage by, and that's in the place of receipt by the pre-carrier. A lot of times the ocean shipments will originate inland by truck, and they will be picked up by the carrier in what is known as a door-to-door movement, which means that the carrier would be responsible for the transportation of a container from point of pickup inland, usually at the shipper's warehouse or facility, take it to the port where it's typically stored for a little bit of time, and then put on the ship for carriage up to the United States. And this is a kind of a typical cargo case that I handle, are northbound moves from South America, Central America, or the Caribbean up to Miami. So we see a lot of times that the ocean carriers themselves will pick up and be responsible for the move from the point of the shipper's facility through to the port, onto the ship, up to Miami, and off the ship there. So you got the port of loading, the exporting carrier, the foreign port of unloading, or in this case, it's the unloading port would typically be Miami, and then the place of delivery. So that's another important aspect of a bill of lading, is seeing where the cargo is actually supposed to end up under the terms of the bill of lading. And again, that extends the responsibility of the carrier. If it's a door-to-door move, that could be at the receiving end's warehouse or container yard. So it might be from the actual shipper's facility inland in, say, Peru, through to a consignee's warehouse in Medley or Fort Lauderdale or Miami, something like that. And that's where this comes into play, the type of move. That's where you'll see the comments, either door-to-door, yard-to-yard, or a combination of those. A door-to-door is just like I said before, it goes from the shipper's facility all the way to the consignee's facility. And the ocean carriers typically responsible for the inland truck transportation on both sides, both at origin and at destination. A port-to-door move would mean that the carrier would be responsible when it receives the container at the port, at the origin port, and then they are responsible for delivering it to the consignee's warehouse at destination. Sometimes you'll see a door-to-port move, which is kind of the opposite. It means that the carrier is responsible for transporting the container from the shipper's facility to, for example, Port of Miami or Port Everglades, where it's discharged, and then the consignee is responsible for moving the container from the port into to their warehouse. The critical thing that I usually look to first, other than the type of move, to see what kind of contractual relationship there is with the carrier in terms of its responsibility for transportation, is looking at the description of the cargo and the number of packages. Typically, in this column where it says marks and numbers, you'll see a container number and then number of packages. Frequently, you'll see the number 1, and that will be one container. And I'm discussing containers because that's usually what the cargo is that we see come in and out of Miami. They're all containerized, so it's cargo, either fresh perishables or dry goods that are loaded into containers. You'll see, so here the carriers generally will put the number 1, and it could, because they want to refer to the package as a container, and then it'll say STC in the description of the commodity, which stands for said to contain. And you'll see then the number of actual boxes, or maybe pallets, or maybe a combination of those two. And that'll be important when we discuss a little bit later on the limitation of liability and the definition of package, which can be and it typically is probably the most litigated aspect of cargo claims. So a lot of times you'll see the number 1 said to contain 2,500 boxes on 8 pallets. As we'll discuss a little bit later, then you got a discussion, okay, well, what constitute the package? Is it the 1 container? Is it the 25 boxes? Is it the 8 pallets? And then down in the left-hand corner is usually the freight monies that are paid. It shows how much it costs to ship the cargo with the carrier. Sometimes it'll have insurance in there as well if the cargo owner obtained insurance through the carrier. And it'll have other ancillary charges as well, maybe some extra fuel charges, which became popular during COVID and before, when the fuel prices got high. They tried to pass along those charges to the customer. All right. Next, we have the identification of the parties. This is also, when I get a cargo case, something you got to really look at from the very beginning is the identification of who's involved and who you're going to sue, who are you going to try to get documentation from. Obviously, from the start, the identification of what company was the actual ocean carrier is very important. Typically in Florida, what we see is the Florida-based carriers tend to be Crowley or Seaboard. Maersk is involved in a lot of shipments here, although they're not headquartered here. They have a fairly significant presence here. And others that come and go as well, but those are the main ones that we see and I deal with here in Miami. The second identification of a party is called an NVOCC. That's what's considered a non-vessel operating common carrier. I'm not going to go into that in too much detail, but an NVOCC has the ability and authorization to issue a bill of lading just like an ocean carrier does. And they're responsible for transporting the cargo under an NVOCC's bill, but they then necessarily subcontract that transportation to an ocean carrier. So a lot of times you may see 2 distinct bills of lading for the same shipment. One is issued by the NVOCC, which is considered a house bill of lading. And then the actual ocean carrier's bill of lading is considered the master bill of lading. Both of those bills of lading have their own distinct terms and conditions. So it's important to read both of them to identify those parties from a cargo owner's perspective or cargo representative. If we're going to file suit against a carrier, if there's an NVOCC involved, we will include them in the lawsuit as well. But they typically get straight indemnification against the ocean carrier. And there may be practical reasons why you want to sue the NVOCC. For example, if they have a favorable forum selection clause that you like better than the ocean carrier, you can argue that your client, the cargo interest, typically would have contracted directly with the NVOCC. The NVOCC subcontracts with the carrier. But the cargo interest can sue the NVOCC. You don't have to sue the ocean carrier. You can sue both, but your main contract is with the NVOCC. And if they have a favorable forum selection clause, and we'll get into that a little bit more in detail later, that would be a reason why you would want to just sue the NVOCC and let the NVOCC worry about either bringing in the ocean carrier in that case, or sometimes they have to pursue the ocean carrier in a foreign jurisdiction in a separate legal action. So number 3 here, you've got the shipper. That's pretty, I think, clear. It's the entity that ships the cargo. They are identified on that bill of lading. And then you have number 4, the consignee, who is the receiver of the cargo. Now, the consignee or the shipper may or may not be the actual owner of the cargo. And that's important to determine who the real party in interest is in any cargo shipment. A lot of times the shippers will ship the cargo to the consignee under FOB terms or other terms of sale where the risk of loss and the actual ownership interest transfers to the consignee, for example, when it leaves the shipper's facility. That's a very important legal aspect to get your hands on and to kind of get your head around, because the real party in interest is a favorite for defense lawyers to say, hey, you brought the name of this case in the name of the shipper, but they're not the real party in interest, even though they are identified on the bill of lading and they have the ability to sue the carrier as such. The shipper, the consignee, and the owner of cargo generally has the right to sue the carrier, but only the real party in interest can survive a challenge on, who has the correct standing and who has the financial risk or the financial responsibility to that own the cargo at the time of the shipment and at the time the cargo was either damaged or lost. Number 6, we've got the insurance company. I do a lot of subrogation cases over the years. Bill Cassidy, my partner, that's what he did a lot of. We would represent subrogated insurance companies that paid cargo claims to the cargo owners, and then they stand in the shoes of the cargo interest, and they file suit either in their name or in the name as subrogee of, or FUBO, the name of the real party in interest prior to the insurance payment, whoever the insured was at that time. So you'll see cargo cases that are brought either solely in the name of an insurance company, sometimes solely in the name of the cargo owner, and sometimes a combination of both, especially if there's a large deductible or uninsured amount involved. You'll see both the insurance company and the insured named as plaintiffs in a court case. Freight forwarders, you typically, even though they're involved with the shipment, they're not typically a defendant in a case. There's fairly strong case law out there that says they are not responsible for cargo damage unless they did something wrong in terms of what they were responsible for, which is typically the paperwork or misidentifying something. Then they may have some exposure. But typically, if it's a cargo damage claim or cargo theft claim, you're going after either the NVOCC or the ocean carrier directly. But on occasion, you will involve the stevedores. Stevedores are the ones that unload the containers from the ships to the shore and vice versa. We've seen a lot of cases over the years where you get punctured or damaged containers that ultimately lead to damaged cargo, either by rainwater intrusion or something else that affects the cargo. We typically would still only sue the NVO or the carrier because they're responsible for that cargo. But a lot of times the carrier or the NVOCC will third party in a stevedore as the ultimate responsible party for the cargo damage. All right. Next slide is the terms and conditions of the bill of lading. I was talking before about COGSA on its own being a statute that applies to a cargo shipment from tackle to tackle. Well, the ocean carriers over the years have put in their terms and conditions of the bills of lading, which are generally speaking enforceable. They're on the back side of that bill of lading that I showed you earlier. There's a lot of boilerplate language on there, including these three main clauses: a Himalaya clause, a paramount clause, and a forum selection clause. These are the three that are probably the most important in terms of contractual liability from door to door and for determining what parties can avail themselves of the protections of COGSA. The Himalaya clause is the clause that extends the protection of COGSA and the terms and conditions of the bill of lading to basically every single person, party, entity, agent that touched or participated at all in the transportation of the cargo. And these two clauses I actually excerpted from the Seaboard Marine backside terms and conditions, since I see them mostly here in Miami. In the Himalaya clause, it is understood and agreed that if it should be adjudged that any person or entity other than or in addition to the carrier, excuse me, is under any responsibility with respect to the goods, all exemptions, limitations of, and exonerations from liability provided by law or by the terms and conditions hereof shall be available to all carriers' agents, servants, employees, representatives, all participating, including inland carriers, and all stevedores, terminal operators, warehousemen, crane operators, watchmen, carpenters, ship cleaners, surveyors, and all independent contractors whatsoever. In entering into this contract, the carrier, to the extent of these provisions, does so not only on its own behalf, but also as agent and trustee for the aforesaid persons. So that's a pretty nice broad clause that extends the protections of the Ocean Bill of Lading to all of the participating interests in the transportation stream of commerce. And it's used all the time. The stevedores, for example, want to benefit from the $500 per package limitation that we'll speak about in a little bit. They want that protection for sure. There are other aspects of the defenses that can be raised by the ocean carrier, and they get the stevedores or any other of these agents or servants get that benefit as well, and it's very important. The second one here is the paramount clause, and that says that provisions of COGSA or such compulsorily applicable ordinances or statutes, except as otherwise specifically provided herein, shall govern before loading, on, and after discharge from the vessel and throughout the entire time the goods or containers or other packages are in the care, custody, and control of the carrier, its agents, servants, participating carriers, or independent contractors, inclusive of all subcontractors, whether engaged by or acting for the carrier or any other person, and during the entire time the carrier is responsible for the goods. That's an important clause that extends the COGSA protection beyond that tackle-to-tackle period that I discussed earlier. This is the clause that contractually extends the protections of COGSA basically door to door for anyone and everyone that's participating in the transportation. Again, a very important clause that extends COGSA throughout the entire transportation scheme. Lastly, just to emphasize here, and we all know what forum selection clauses are, they're extremely important for the carriers to determine where they want to be sued. They are fully enforceable ever since the Sky Reefer decision in 1995 that talked about arbitration clauses, but the forum selection clauses are fully enforceable as well. Even if you have to sue an ocean carrier in the Philippines or Tokyo or Hamburg or Marseille, France, all the carriers a lot of them have jurisdictional clauses in those countries. Even though COGSA might apply because it's a shipment to or from a United States port, you still have to sue the carrier in that jurisdiction. And Sky Reefer said basically just because a foreign court has to deal with an arbitration or a forum selection clause, and they may not know COGSA that well, U.S. COGSA, you still have to file suit there, and they have to apply COGSA. And that is and has been a very important limitation for cargo, especially lawyers in the United States, from suing ocean carriers and NVOs in the United States. We are fortunate that Seaboard has a Miami forum selection clause, and Crowley has one. I believe that's throughout the state of Florida, or maybe the Middle District of Florida. They're headquartered up in Jacksonville. But you have like CMA, CGM has a Marseille, France forum selection clause. You have Hamburg Sud and some other the German carriers typically will have a Hamburg Sud or a Hamburg, Germany forum selection clause, rather. The Far Eastern carriers will have forum selection clauses in the Far East, Philippines, Hong Kong, and those can be obviously quite daunting. And that really chills the ability of cargo to pursue claims, especially on a contingency fee basis. If you're trying to get a lawsuit pursued in one of those foreign jurisdictions, it can be practically impossible to pursue. All right, moving on. Cargo types. We've been talking about containers, but they're also break bulk cargoes. We handle mostly containers here in Miami. There is more break bulk up in Port Everglades, cement, for example, and cargo owners typically ship most of their goods now in containers unless they are break bulk, large cargo hold type of product that are going into the cargo holds rather than in a container. But COGSA still applies to either one. It's just more of a matter of whether a package limitation will apply to those or not. All right. Carriers' defenses. 46 U.S. Code Appendix 1304 A to Q was the original codification. So I'm still going to use that, even though technically the citation has changed somewhat. It still goes by, I think, Section 4, A through Q, instead of 1304. But these are important defenses that we see trying to be used by the ocean carriers all the time. The first one is the act, neglect, or default of the master, mariner, pilot, or the servants of the carrier in the navigation or in the management of the ship. That's called the errors in navigation defense, and that is often brought up in collision cases, cases where there has been something happened that's the fault of the pilot or the captain. For example, if the ship that crashed into the Baltimore Bridge, if that was obviously a power failure, but if for some reason the master, the captain of the ship misnavigated that ship, you would rest assured that the carrier would bring that up as a main defense that they have under COGSA that would shield them from any liability. Next, we have the fire defense, and that is used from time to time on fire cases, unless it was caused by the actual fault or privity of the carrier. And that's an interesting defense that I have seen raised a couple of times, where there's been a fire on board the ship, but the ship didn't have a proper fire watch, or it was caused by something that happened that was the direct fault of the carrier. So I don't think, unless it's some spontaneous fire, something that's caused from some outside source, most of the time the fire is going to be caused by the actual fault or privity of the carrier. So I'm generally speaking not too concerned about that. Next, the perils, dangers, and accidents of the sea or other navigable waters. That's basically, any of the perils of the sea. We don't see that too often now. These ships are so big, they don't get, you don't see too much damage from a peril of the sea. It kind of mixes with the next defense, the act of God. That used to be more effective, I think, way back when, before all of the good meteorology that we have now. Act of God, for example, hurricanes. The ships have long-range radar and other aspects of weather prediction that they can use to avoid these storms. So again, unless something really pops up and it's something beyond their control, those defenses usually fail. Act of war, act of public enemies, that would be more obviously applicable in Europe and Israel and the Gaza Strip now. That could be, something where, where they've been, the ships have been attacked out at sea out there. If it was a shipment to or from the U.S. port, that would certainly be a defense that could be raised if the strikes against the ships damaged any of the cargo. Arrest or restraint of princes, rulers, or people, or seizure under legal process. That's where if the government does something. Don't see that very often, but it does. It's out there and it does happen from time to time. Quarantine restrictions. Although I didn't have any case specifically about it, if you have, for example, during COVID, if there was quarantine restrictions and, for example, the ships couldn't go into port, right, because of problems with COVID and trying to keep ships from entering port, and the quarantine restrictions that were around that, and there was cargo damage, that would be an applicable defense, I would think. Next one, act or omission of the shipper or owner of the goods, his agent or representative. We do see that from time to time. It's probably one of the more common defenses, is due to either improper packing, and that's down at letter N as well. But if anything is done by the fault of the shipper, that can be used by the carriers as a defense. You got the strikes or lockouts or stoppage or restraint of labor from whatever cause. We've seen that. Remember when the ports we're jammed up and we're really backed up. You have a lot of labor strike issues throughout the world. Either it was due from COVID or some other aspects when there was strikes. I was contacted by a lot of cargo owners where in Port of Los Angeles in particular, there were several weeks delayed in getting some ships in there, either due to strikes or a labor problem. That was a significant cause of some of these cargo damages, and that was a defense that was being raised by the carriers. Going on further on down, inherent defect. We see that or inherent vice of the goods. I see that in perishable shipments. That's raised a lot, saying, hey, this cargo just deteriorates on its own by its own inherent vice. But that can generally be overcome pretty easily by other aspects of the case itself. Insufficiency of packing, that's the fault of the shipper in not bracing the cargo well. That does happen from time to time. Latent defects, that's out there and not discoverable by due diligence. That's a fairly well-used defense as well. And then you got the Q clause. This is any other cause arising without the actual fault and privity of the carrier and without the fault or neglect of the agents or servants of the carrier. But the burden of proof shall be on the person claiming the benefit of this exception to show that neither the actual fault or privity of the carrier nor the fault or neglect of the agents or servants of the carrier contributed to the loss or damage. So that's sort of a catch-all defense that we saw in hijackings, for example, or outside third-party theft. That would be used because actual theft is not a defense. If it was the action of a third party, the carrier would typically be on the hook for that. But they use the Q clause defense to try to get around that, to get around their liability for hijackings or thefts. But hijackings and thefts since 9/11 don't happen very often. They still happen from time to time, but not as much as they used to. Moving on. All right. Burdens of proof. This is probably one of the most interesting aspects of cargo cases from my standpoint, because it's a pretty easy prima facie case to prove liability under COGSA for the fault of the carrier. The plaintiff can prove a prima facie case by showing delivery of the cargo to the carrier in good order and condition and delivery at destination in a damaged condition or with shortages. So that happens, that basically just means that we have to get someone on behalf of the shipper to testify by affidavit, deposition, or otherwise that they loaded this cargo in good condition into the container and sealed it at the time it was delivered over to the carrier or the carrier's trucker. It can be somewhat of a challenge to get the cooperation of a shipper, but 9 times out of 10, we do get that, and we're able to obtain either an affidavit or their deposition testimony that establishes that first prong of the prima facie case. Delivery at destination in a damaged condition or with shortages is probably the easiest thing to prove because your client, the cargo owner, is generally going to be the consignee, the one that receives the cargo and the one that discovers that it's damaged. So you, generally speaking, have a pretty easy second prong to prove by affidavit, deposition, or otherwise that when they received the cargo, opened up the cargo container doors, they saw damage. And they called a marine surveyor, they got it all documented, and then you presented the claim to the carrier. If a prima facie case is made out by the plaintiff, the burden shifts to the carrier to establish either that it exercised due diligence to prevent the damage to the cargo by properly handling, stowing, and caring for it during transportation, or that the damage was attributed to an accepted cause under Section 1304(2) of COGSA, which Those were the defenses that we just went over before. The carrier has, in my opinion, and I think most cargo lawyers would agree, a more difficult time trying to establish their burden of proof that it exercised due diligence because, and this is why the scheme is how it is, the carriers typically don't see the cargo in a container unless somehow they or an agent of theirs participated in the loading of that container or were present when it was loaded. Typically, they get a sealed container at origin, and they deliver a sealed container at destination. If something happened to the cargo in between, a lot of times they don't know what could have caused it. If there's rough handling and physical damage to the cargo, the container may not show signs of it. Then the carrier is not going to have any chance of really proving that it was free from fault. As long as the plaintiff establishes that prima facie case, it's very difficult, in my opinion, for the carrier to get out of liability. But in a trade-off for that nice liability scheme, the carrier has two very powerful limitations at its disposal. The first is a statute of limitations that is contained, codified in COGSA as a 1-year statute of limitations. So a very short period of time for cargo owners or their insurance companies to file a lawsuit against the carrier. As we all know from the passenger cases on cruise lines, the 1-year statute shocks a lot of lawyers throughout the United States that don't do cruise line work or cargo work. And a lot of times they blow the statute before I see the case. So that's a powerful defense that's enforceable by the carrier. And the 1 year runs from the date the cargo was delivered or should have been delivered. A lot of times cargo may be missing and never gets delivered. So if the cargo would have arrived there on its regular schedule, that's when the clock starts running. The other significant limitation at the carrier's disposal is the aspect of damages and the $500 per package limitation. So the COGSA says neither the carrier nor the ship shall in any event be or become liable for any loss or damage to or in connection with the transportation of goods in an amount exceeding $500 per package lawful money of the United States, or in the case of goods not shipped in packages per customary freight unit, unless the nature and value of such goods have been declared by the shipper before shipment and inserted in the bill of lading. As you can imagine, what is deemed to be a package is and has been the source of a lot of litigation over the years. You may have recalled earlier I said, well, that bill of lading may describe the package as the container. It also may contain a description of the number of boxes, or it also may show the number of pallets. I do a lot of perishable shipment cases coming up from South America to the United States, and they frequently have that one container said to contain 2,400 boxes on 8 pallets. There's pretty good case law that says as long as the number of boxes is identified in the bill of lading to the carrier, I think the majority of the case law will hold the package to be a box, but sometimes it's considered to be the pallet if the pallet is contains banding or is used in such a way that a court might consider, well, a pallet has 20 boxes on it, heavily strapped and then shrink wrapped. That seems to me to be a package. And that's quite possibly a good defense for the carriers to use, that it's the pallet. If it has that type of preparation, that would be considered the package and not the boxes. in any event, that's what we all litigate over, and why I'm here talking to you today is because that's very often a point of contention. And quite frankly, a lot of times the reason why cargo cases get settled because cargo interests don't want limitation to be the 8 pallets, but the carrier doesn't want it to be 2,400 boxes either. So, a lot of times you'll find a middle ground, and that's a good area to settle a case. Moving on. All right, talking about damages. I said earlier, I like this aspect of cargo because it's a fairly easily identifiable amount of money. Typically, the measure of damages in cargo cases under COGSA is the fair market value at destination. For example, those perishables, the boxes of asparagus that come up from Peru to Miami, either they're pre-sold to their customer at a certain price, which would obviously be their damages, or they're sold at the USDA market price that's in effect on the day that they attempt to sell the product. And that's a great indicator of fair market value. The USDA has a report every day of what the value of Peruvian asparagus is in Miami. It could range anywhere from $10 a box to $18 a box, thereabouts. But each day it might vary based on demand and based upon the condition of the cargo coming up from those particular countries. Obviously, as cargo interests, we try to get the highest damages possible. So fair market value at destination is generally the highest value you can get. But sometimes you're limited to cost and freight. For example, household goods or goods that are not going to be sold to a buyer at destination, you're typically going to be stuck at the cost plus the freight you pay to the ocean carrier. Just had a case involving a shipment of brand new household goods that were going down to the islands, St. Thomas, I believe. And, whatever they paid for that cargo going down, because they weren't going to resell it, they were just going to put it in their house. They were building a house and they were furnishing it. The cost that they paid for it is their damage. That's just it. But it's pretty straightforward. And the freight is what they paid to the carrier for transporting the cargo. Sometimes you'll get an issue where you have partial cargo damage, and the issue is, well, the freight is earned. Can you get back some of the freight that was paid for the cargo that was damaged? Typically, my answer would be yes, but it's fairly negligible. I mean, most of these containers are being shipped for around $5,000, although during COVID that went up some. But it's a really competitive market, so the freight rates are fairly low. And that's why you also don't see cargo interests declaring value of their cargo to pay higher freight charges, because if you do that, it's basically trying to get the carrier to be an insurance company. And they'll do it, but they're going to charge you about 3 or 4 times the amount of the freight to transport that cargo. And most cargo interests that I know want to get the cheapest freight rate, and they'll roll the dice. A lot of times they won't get insurance, and sometimes they're stuck with the package limitation. One of the kind of bad examples of the application of the package limitation are on vehicles or yachts that are being transported by ship. You put a car into a container, you ship it to wherever, that car gets damaged, destroyed, whatever, you're limited almost all the time to $500 because there was a lump sum freight that was applied to that car or the yacht. And that's where you see probably the most significant limitation on a package issue is with the yachts that are being transported in cradles over the ships, or with the vehicles. And a lot of times they're exotic cars. A lot of times they're cars that are, you see those vessel fire cases with the vessels going into Jacksonville that caught fire. They had a few of those the last few years. You're looking at a $500 per package limitation. So getting insurance, if you're doing that type of business, you got to tell your client they need to insure that yacht or those vehicles for first-party insurance and do not rely on a liability scheme to protect them under COGSA. All right, getting towards the end here. These are the documents that I look for whenever I get a cargo claim come into my office. Clearly, the bill of lading or an airway bill if it's a shipment by air, same type of thing. That's your starting point. That's who you're identifying, who the parties are. That's who, you're identifying the cargo, how it's described. And then the next really important thing are the survey reports. Cargo gets damaged. The good cargo and experienced cargo owners will call a marine surveyor, a cargo surveyor who will go attend the viewing of the cargo as soon as the container doors are open or within 24 hours of that, and document everything. They'll take photographs. They will talk to people. They'll download temperature recording devices if it's a perishable or a refrigerated shipment. They'll do all the legwork for you, and this is usually well before a lawyer will get the case. Those survey reports can be very important, and the ocean carriers get their own surveyors as well. So both sides document the condition of the cargo and use that for negotiating and understanding the cargo case going forward. USDA reports, if it's a perishable case, a lot of times the cargo interests will call the USDA. They come out fairly cheaply and do kind of a mini survey report. That can be beneficial, especially if your client didn't pay for a full survey report. You got the commercial invoices. Those usually are issued by the shippers that show the cost of the product from port of origin. And proof of payment of the, it goes back to who the real party in interest is, right? So who still has that risk of loss, who owns the cargo. Then you go into the sales and the salvage records, and were they able to mitigate damages and sell part of the cargo? Were they able to salvage some? If not, did they destroy it or send it to the dump and get dump tickets or some type of proof of destruction? The USDA market prices that I talked about earlier, that's important. Then you have all these other documents too that go into a full inspection of the cargo claim itself. Last but not least, I didn't want to end my presentation without speaking of the hope on the horizon. The U.S. Carriage Goods by Sea Act has been in existence since 1936. That $500 per package limitation was put in there in 1936. So we all know that that amount is ridiculously low now and should be increased. So there have been efforts on an international basis to come up with an entire new comprehensive international cargo rule that is now, it's considered called the Rotterdam Rules. This was put together by the United Nations, and a lot of countries have signed on to it. This little map shows that, the United States here has been a signatory. A bunch of other countries have signed on to it, but only 4 countries have actually ratified the Rotterdam Rules. And these were brought forward in 2009. And you have countries like the Congo, Spain here has ratified it, a couple of other smaller countries in Africa. But the United States, it's been pending in Congress since 2009. I was at a committee meeting for Carriage Goods by Sea Committee in the Maritime Law Association last week, and they've been talking about passing these Rotterdam rules for 20 years, and they're still trying. Most all the players are in favor of passing the Rotterdam rules, and even the carriers, everybody. There's just a couple of holdouts here in the United States, typically port authorities, that want something more than just what the new Rotterdam rules are giving them. But to summarize, the new Rotterdam rules would incorporate a Himalaya clause, would incorporate the paramount clause, would increase the package limitation by almost 3 times. The 500 would go closer to 1,500, and it has an alternative that it's based on the weight of the cargo, whichever is greater. And lastly, it has a 2-year statute of limitations instead of a 1-year. So we're all, I wouldn't even say holding our breath because it's been sitting around for 15 years, but there are more and more efforts to try to get this approved. It needs to be changed. We're talking 2024, and COGSA hasn't been updated since 1936. So I hope it does get improved upon, and I hope it does get passed. And that's my presentation today. So if anyone has any questions, I would love to answer them. Otherwise, thank you very much for your time.